Hi friends, I welcome you once again. Today the topic of discussion is a very prominent concept of Indian Evidence Act known as Dainik Declaration. The provision with regard to Dainik Declaration has been incorporated under section 32 subsection 1 of Indian Evidence Act. Now before I come to the core issue which we are going to discuss in the next 10 minutes, I would like to explain here the rules of evidence. Now in order to establish the innocence or the guilt of the accused, court has to examine the evidence adduced by either by the prosecution or by the defense. After weighing an appreciation of evidence, the court has ultimately to come to the conclusion. So evidence plays a very important role. Only in the light of the evidence, any case or the fate of the concerned person could be decided. So three cardinal rules which you have to remember as far as the law of evidence is concerned. One is that evidence must be confined to the matter in issue, meaning thereby only the relevant evidence should be admitted. Right? Now in order to prove the fact and issue, the inference is to be drawn by the court to the existence or non-existence of fact from the relevant facts as well. The relevancy of the fact has been very well defined under section 6 to section 55 of Indian Evidence Act. A lot of provisions have been done. Section 32 is one of that provision which we will be discussing. The second cardinal principle is that hearsay evidence should not be admitted. My dear friends, hearsay means suni sunai baat. The person who has not heard, who has not seen, who has not perceived with the senses anything, he should not be allowed to come into the witness box and deposed to the fact which he has not experienced himself. So the hearsay evidence should be discarded outrightly and it should not be allowed to be admitted. Third rule of the Indian Evidence Act is that the best evidence must be given. So if it is in the form of the documentary evidence, then it must come. If it is oral, it has to be direct, preferably. But there are circumstances take place when the direct evidence is not available, then the indirect evidence by way of either the secondary documents or through the circumstantial evidence. Fine. Ultimately, the court has to reach to the conclusion and determine the facts and issue before it. Now, in order to do that, the court preferably should try for the best possible evidence to be available, to rely on that evidence. If it is not, then the other evidence should be taken in consideration, right? So section 32 talks about three things. One, that statement by person who cannot be called as a witness. Now it talks about four kind of persons. Person number one, who has been dead, who is no more. Person number two, who cannot be found. And person number three, who has become incapable of giving evidence because of the illness, infirmity, or is in a coma or a vegetative state of mind, or he is not able to depose. And the fourth, the person whose attendance could not be procured without an amount of delay or expenses, which under the circumstances court appear that it would be very unreasonable. So if court feel that it would cause undue hardship and the inconvenience and will cost very expensive and would be unreasonable, then the statement whatsoever these persons have already made would be taken into consideration, they will not call. But here today our focus is going to be on section 32 subsection 1, which deals with the Dainik Declaration. My dear friend, Dainik Declaration simply means a statement or a declaration by a person who is dead. Now here two things which you have to remember. One, statement or a declaration with regard to the cause of the death of the person who has made it, and second, the circumstances of the transactions which he declared or highlighted and resulted into his death. So you can divide it in two parts. It is not mandatory that a person who has been making a statement should be under the expectation of death. I mean, he should be apprehending death only, and then only his statement would be considered after his death as a Dainik declaration. It is not so in Indian law. Here the Indian law differ from the English law on this very account. Under the English law, the person has to be under the expectancy of death while making the Dainik declaration. But as far as Indian law is concerned, the statement, if it has been made with regard to the transactions, with regard to the circumstances of transactions, even then it would carry the same value, it would carry a lot of weightage, and it would be considered as a good piece of evidence, you can say. The term circumstances of transactions which you need to understand here is that it must not necessarily be a direct nexus between the circumstances and death. It is not mandatory at all. Fine? Even a distant circumstances can become admissible if it has nexus with the transaction resulted with death, my dear friends. So in a Pakala Narayan Swami case, very important and landmark case on the subject is the disease. I mean, he handed over the letter to his wife and stating that he is going to collect the debt from such and such fellow, but he was found dead, his body was recovered, and this piece of letter or the statement which he made before going to the person from whom he is to collect money was taken into account as a dying declaration. So, my dear friend, it is not that you are lying on a state wherein the death is expected and then only you make a statement to be considered as a dying declaration, but anything. This is the core difference between the English or Indian law which you need to understand. So, the question arises, can dying declaration be a sole basis for the conviction? Answer is in affirmative, yes. Why? Each case has its own fact which is to be determined by the court in the light of the evidence. Now, a scuffle took place between the two fellows, one stabbed the other, and the person who collapsed, who died, there is no other witness to that incident. Now, he is the only witness who can describe, or before his death, or before even the scuffle, if he has uttered something to somebody as to the circumstances as we discussed, and that would also be considered as a dying declaration. Fine. So, it is a substantive piece of evidence. If it is correct, consistent and reliable, court can base the conviction on the basis of this only. Few more points which you have to remember, that dying declaration is not a deposition in a court of law. It is neither made on oath. It is not tested by the cross examination. Admitted by way of an exception to the admissibility of hearsay evidence. As we initiated, we said that hearsay evidence should be discarded and it should not be allowed to be admitted in the court of law. But this dying declaration is an exception to the rule of hearsay evidence. Okay, because it is on the basis of necessity. If there is no other witness available and this witness who has ultimately been collapsed, deceased, died, and his last word should be given an importance. My dear friend, this is based upon a Latin maxim. You can write down that maxim, that is nemo moritus presumetur mentor. This is what you need to remember because it's difficult to pronounce it. It simply means that man will not meet his maker with lie in his mouth. So, the Indian law recognized this principle that a person whosoever is going to meet his maker or a creator, he will not go with a lie in his mouth. Fine. So, the other principle which is similar to it is that dying man seldom lies, and the third one is the truth sits upon the lips of a dying man, कि उसके होठों पे हमेशा सच्चाई रहती है जो मरने जा रहा है, ठीक है, और वो कभी झूठ नहीं बोलता जो मरने जा रहा है. वो just to satisfy or wreak his vengeance will not implicate somebody while dying. So, the importance and the weightage to the sentiment we being sentimental society is always given. So, my dear friends, now there's a lot of questions like on this area are being asked time and again, and what you have to remember here is that the victim is the only witness. The exclusion of his statement might defeat the end of justice. So, keeping in view this principle, this has been always kept on the highest pedestal and given due weightage. So, latest cases, I will not give the citation due to paucity of the time, but I will just discuss the area wherein the Supreme Court has recently laid down number of judgments. So, one of the questions before the Supreme Court was that can it be discarded merely on the fact that relative of the deceased were present in the hospital? The Honorable Supreme Court held that no. See, it is but natural. If somebody is fighting for the life and lying on the deathbed, then it's but natural that the relative would be present. Just in order to inquire about his well-being. Fine. So, the Honorable Supreme Court has recently held in a judgment dated 4th of March, only on this ground, the dying declaration cannot be negated or discarded. And second is that if the person has to be in a fit state of mind while making the statement, this is a general rule. Fine. If it's not a fit state of mind or the certificate to the fitness has not been obtained, so can it disapprove the dying declaration? The Honorable Supreme Court again said that no, it would not if the version appears to be true, fine, then it will not. So, it is a judgment dated again 12th of February 2001, which you can go through on the net. And with regard to dying declaration, you can see lot of judgments because this area has always been an area of discussion. Fine, a divergence view were being taken by the court, and ultimately the Supreme Court gave number of rulings on this. Plethora of judgments you will find on it. Fine. So, if a person is say suffering with the 100% burn injury and was not capable to give the dying declaration, then even the Honorable Supreme Court said that if he give it by a sign or a gesture, like in Nirbhaya case we have all examined and observed there are 3-4 statements, one by the police, then by the executive magistrate, then by the judicial magistrate was recorded. But since there was consistency on the statement, fine. So only on the basis of those statements, the ultimately accused were nabbed and subjected to prosecution and punished in accordance with the law. See, this is a very old case, that is Queen Emperor versus Abdullah, wherein the throat of the disease was chopped. She was not able to name anybody, she was not able to speak, but through the sign and gesture she named the accused, and ultimately he was convicted for causing death of the disease. And so there are so many examples you will find, but you have to have a command mastery. You need to explore the judgments also. In our detailed discussions, regular lectures, we would certainly be discussing on each and every point, but herein, because I just wanted to give you a broader idea. Now there is a lot of confusion as to whom it should be recorded, when it should be recorded. See, somebody is fighting hard for the life. He need not to wait for the concerned person to come and then record. If he'll keep on waiting for the judicial magistrate, the only judicial magistrate is empowered to record the statement, then I think it would be very fatal, and will bring injustice to a person who is, I mean, on the verge of death. So whosoever is available, whether the relative or the police or the executive magistrate or the doctor, it could be recorded to anybody. The court ultimately has to test its consistency, its reliability, its truthfulness, and accordingly weigh it and decide the fate of the case. Fine. So I think it is enough for, yes, one more thing, like mechanical approach relying upon dying declaration is extremely dangerous. The Honorable Supreme Court has held in one of the case that mechanical approach is not, wherein it seems to be inconsistent, then the other material on the record and the corroborative material is to be seen. Fine. If it is established the guilt of the accused, then of course it could be taken into consideration, and on the basis of it only the one could be punished. So my dear friends, I think it is enough for today. I have given you the broader view, then rest of the things we'll be discussing in the detailed lectures. Thank you so much for hearing.